I'm going to tell you about proving legal theorems. This is based mostly on a pair of works, one more technical with Kobe Nissim and one more legal, also with Micah Altman and Alexander Wood. So I'm at BU, and thanks for the people who brought me to BU for supporting this sort of work. And there's a lot of NSF people in the audience, so also thanks NSF. Some of this was supported by an eager grant, which was mentioned in the last session. And thanks to the organizers, David and Joan and Josh, for putting together this workshop. And yeah, if you or your CS department is interested in more work like this, let me know. And the middle, I want to warn people that the middle third of this talk is going to be a little mathy, but everything else should be pretty accessible, and I'll call you back. So just to start, the workshop description talked about establishing rigorous foundations, co-development of computational, technical, and legal principles, and building shared understanding methodology. So I want to focus on this phrase, this co-development of computational techniques and legal principles, and ask just sort of, what does that mean? And so I made this slide now after Josh's talk. I realized that what I'm really talking about here is Ed Felton's third law, that a lot of times what people think about when they think about CS and law, a lot of work is more sort of law for CS, like regulating the use of facial recognition or the Digital Millennium Copyright Act or Section 230 or cookies. And some of it is more CS for law, discovery, we heard about discovery, digital forensics tools, robot lawyers, automated legal advice. But this phrase, this co-development of legal, sorry, co-development of computational techniques and legal principles, I think alludes to something more integrated, is CS and law. And what I hope to convince you today is that so I'm a computer scientist, as Danny said. I got my PhD at MIT doing cryptography. And I want to convince you that by more seriously engaging with legal thinking, we can surface new basic technical questions that have legal salience. So as a cryptographer, I study the tension between the theory of cryptography and privacy law and surveillance. And ultimately, the goal is, as the organizers put it, to establish rigorous foundations and to develop shared understanding. So what does this look like? So this workshop is sort of what this looks like. And so I'll mention, before I really get into the meat of it, some examples of what I'll call legal theorems that are at this very workshop. And just to be clear, like there's other work. I'm only going to tell you about some of the work that I knew about before today. And I'm not claiming that these distinctions are clear cut or that anything is better or worse than the other. So one type of legal theorem is just technical work that has direct law and policy implications. Another type, which Sarah talked about is earlier today, is cryptography against legally powerful adversaries. And a third type, which I think is a little bit different, is developing hybrid technical legal concepts. So, and that's where we'll spend most of the time for this talk. But just quickly, so for example, a few years back, the census developed a new disclosure avoidance algorithm. It's based on differential privacy, but it does a lot of other things. And census data is hugely consequential. It's used for congressional apportionment. It's used for budget formulas. It's used for drawing districts and challenging gerrymandered districts. And the new disclosure avoidance algorithm seems like it's going to disrupt a lot of data users, which raises new questions. So for example, most legislative districts today are balanced to within a single person. Populations are balanced to within a single person according to the last decennial census count, so the 2010 count. But now that census block population counts are going to be off by some tens or maybe a couple hundred people, it's no longer clear. We can't hope to even pretend like we get this equal population, these equal population districts, these exactly equal population districts. So what's the best way to draw sort of equal population districts? We can't do what we did before. So anyway, if you're interested in this, there's a poster in the poster session and also in the room at the bottom of Gather about this stuff. So Sarah mentioned this work about the Fifth Amendment, and so I just want to sort of I think it's great work, and I want to sort of interpret it, offer my own interpretation for a minute. So good adversarial modeling, so I come from cryptography, good adversarial modeling requires understanding the context. The context, both like computational and the social context. So some adversaries have powers that go beyond their computational powers, which are the ones we usually think about in cryptography. So for example, the government can force you to do things or throw you in jail if you refuse to do those things, right? So that's a power beyond, running computations on a supercomputer for a week. But that power isn't limited, and they're bound by law, and they're bound by the Constitution, they're bound by the Supreme Court. So what the work that Sarah was talking about argues is that cryptography that explicitly accounts for these extra powers and their limits can protect individuals from an abuse of government. And I think this is a good example where the legal the engagement with the legal question sort of came first, and then a while later was so in this work with that Danny mentioned with Sanu Park, who was also at MIT, we just wrote like a law review article wrestling with these questions and arguing that you could design cryptography to make compelling decryption more difficult legally. And then Mayank and Sarah and Mayank sort of took that to the next level by offering mathematical formalisms and proving theorems about what can and can't be compelled. So I think this is a great example of like a legal theorem. And finally, very quickly, I want to mention work on the right to be forgotten. So here's a basic question. So let's say some company uses your data, your online profile, to train and publish a model that does something. And later you erase your profile from the company's website, and you say, I invoke my right to erasure. So the question is, should the company update their published model? Right? There's a lot of recent work on so-called machine unlearning, which gives algorithms for removing the effect of a person's data on a model. But those works answer the question of how to update the model, assuming you want to update the model, but don't really wrestle with the should the company update the model. If all you care about is the confidentiality of the data, then sometimes you shouldn't update the model. In fact, updating the model can leak information sometimes. And there's this recent work that appeared in Eurocrypt this summer that formalizes a version of the right to erasure that precludes publishing the model in the first place. But what if what you care about is not confidentiality, but it's individual autonomy and control over the use of their data? So for example, if the data was collected without consent. So maybe the user wants you to update the model. They object to the use of the data, even if updating the model is going to leak some information. And this type of thing is not what computer scientists usually mean when we talk about privacy, but outside computer science, it's one of the things that people mean when they talk about privacy. And this is like outside the sort of things that we usually think about in cryptography. So there's also a poster on this in the poster session. Anyway, so I want to spend the rest of the talk talking about hybrid privacy concepts and focusing on a case study in my work about predicate singling out. And so for those of you who have seen me talk about this stuff before, the focus will be on sort of different stuff. So there's going to be new things and at least new pictures here for you. So continuing on the data privacy theme, there's a lot of privacy laws, right, that tell you what you have to do at a high level, what you have to do with data or what you can't do with data. And there's a lot of privacy techniques that tell you what you can do. You can encrypt, you can compute certain private statistics. And every technique and every law you can ask, sort of an obvious question, which is, does the technique satisfy the law? So for example, does differential privacy, one of the techniques on the right, de-identify under the HIPAA expert determination standard, right? So let's just look at HIPAA and let's just look at differential privacy. So here's the HIPAA expert determination standard. It's a lot of text. An expert applying generally accepted statistical principles determines that the risk is very small, yada, 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 to identify an individual who is the subject of information. So this is what's in the regulation, in the privacy rule. And this is what differential privacy says. So I have these two things. What's the next step? It's not at all clear where to go from here. And so what we argue, me and my collaborators argue, that to make progress, one thing we can do is break the problem into smaller pieces. And so we propose instead to start with the underlying privacy concepts. So privacy laws are built on foundational legal concepts. Some, like these on the left, some of these look really, really weird for computer scientists. In the same way, cryptography is built on foundational legal concepts. Sorry, not foundational legal concepts, foundational mathematical and technical concepts. Both have sort of their firm foundations, rigorous foundations. And what we propose is to develop hybrid concepts that bridge between the two realms, concepts that function both legally and technically. So to develop the hybrid concepts, we have to move between legal analysis and mathematical analysis. So what does that look like? First, you have to understand the law on its own terms, extracting relevant legal text, and then try to formalize it. Once you have some formalism, analyze it, see if it makes sense. If it doesn't, maybe go back to the law, try to understand it some more, draw legal conclusions, formalize, and there's this whole back and forth until you sort of maybe get something that makes sense, hopefully. It's sort of slow going in a lot of ways, but it raises interesting technical questions that have legal salience, like I said before. So as a case study, I want to tell you about how this back and forth on a topic, on something called singling out, which is relevant to the GDPR. So here's an outline of the rest of the talk. First, I'll tell you about the GDPR and what singling out is, on GDPR singling out, which is how I'll refer to the legal concept. And then I'll tell you about predicate singling out, which is our new hybrid concept. And then I'll tell you about sort of going what this has to do with anonymity, which is a privacy technique, and the conclusions we can draw once we have this hybrid concept. Cool. So, okay, first, what's the GDPR? For those who don't know, the GDPR is the General Data Protection Regulation. It's this big omnibus privacy law, went into effect in Europe a couple of years ago, and it governs everything. It's why in May of 2018, you got a bunch of emails telling you that your privacy policies were being updated and asking you if you wanted to stay or be removed from mailing lists. It's because of the GDPR. Cool. So what does the GDPR regulate? It says, as it is said, as it is written, this regulation lays down rules with regards to the processing of personal data. So personal data is the object of regulation. And the GDPR also says that the regulation should not apply to personal data that's rendered anonymous. 1 second, I just want to adjust something on my screen. Okay. It should not apply to personal data that's rendered anonymous. So this suggests that, or sort of if you read this, it tells you that if it's not personal data, the GDPR doesn't apply. And this suggests something that sort of a way to get GDPR compliance for free, in a sense. Take your personal data, what I'll call X, feed it through some magic box, which I'll call M, and out comes something, M of X, which is this anonymous data. This is the personal data rendered anonymous. And so the question that's raised by recital 26 and this picture is, what do we need from the magic box M in order to say that M of X, its result, is anonymous? Okay, that's the question. That's the legal question. So the GDPR goes on to say that personal data is any information relating to an identified or identifiable natural person, and that to figure out whether somebody is identifiable, account should be taken of all the means reasonably likely to be used, such as singling out to identify a person. So singling out is one way of identifying somebody. It's actually the only way specifically mentioned in the recital, which is part of the law, to identify somebody. Okay, so singling out is a way to identify. It's not the only way to identify. There's these other, the purple way and the orange way, but singling out is one way to identify. And that if you want to do GDPR anonymization, that magic box must prevent singling out. Whatever singling out means, it must be prevented in order to say that your magic box is a general purpose anonymizer under the GDPR. And so what we want to do, what we do in this work, our goal is to come up with some precise notion that is necessary for GDPR anonymization. So GDPR anonymization implies that you prevent GDPR singling out. That's what the red thing inside the blue thing tells you. We want to say that preventing GDPR singling out prevents something else, and we're going to call that thing predicate singling out, PSO. So we want a necessary condition for preventing GDPR singling out, and therefore a necessary condition for GDPR anonymization. And with that, by focusing on that necessary requirement, it means that negative results are the most legally meaningful. They give you a way to refute. It gives you a way to refute purported anonymization mechanisms. So if a purported technique allows predicate singling out attacks, then you can conclude it's not a GDPR anonymization technique in general. It also allows us to restrict the scope. So I'm gonna, in a couple of slides, I'm gonna make this like strong distributional assumption. And if you're a computer scientist, you might be like, whoa, it might raise your hackles. But the answer to your hackle raising concern is that we're focusing on a necessary condition. And by focusing in that way, it allows us to restrict our scope in such a way that makes it easier for us to develop new concepts and new techniques. Cool. So our departure point from the legal to the technical is a view of GDPR singling out as something called that we call isolation. And this view comes from some guiding documents put together by a legal body, the Article 29 Working Party, and from a paper up on Archive that was put together by a privacy startup, basically selling anonymization software. So what's isolation? I'll tell you by example first. Here's a database. Let's say it's like the Netflix database. And so you isolate if you can output a description that matches one person. So one person rated the movie Crash of 4. One person watched Mulan in March. So that's examples of isolating. Okay, let me move on to the math. So what's the setting? There's this database X, which I already mentioned to you. I assume it's drawn from a distribution. If that's meaningless to you, don't worry about it. Feed it through this anonymization mechanism M, out comes the output. You give it to an adversary. You give it to some party A who outputs a predicate. And that predicate is predicate is like watched Mulan in March or rated the movie Crash of 5. That predicate is a property of rows that is either true or false. And the adversary's goal is to output a predicate that matches exactly one row in the underlying database. We say, if he does so, we say that the adversary isolates. So it turns out that isolating is trivial. It's easy to do. And what I mean by trivial, it's possible to do even if you don't look at the output of the mechanism. So the adversary, so for example, this adversary outputs P star. There's this predicate P star the adversary can output without looking at the mechanism's output. So for example, consider if the mechanism had 365 random people drawn from a university's population, and the adversary guessed that there's exactly one person born on February 2nd, right? You'd expect that there's on average one person, and it turns out it's easy to calculate that the probability that there's exactly one person is about 37%, even without looking at the database or any computations done on the database. So isolating is trivial, at least up to 37%. Turns out you can't do better than 37% without looking at the data. So what makes isolating non-trivial? So one thing is if you say if you guess one person's born on February 2nd, and you're right with 97% probability, much higher than 37, which suggests that there's some improvement over a baseline that is important here. But the baseline is not fixed at 37%. So for example, if the adversary was able to guess that there's one vegan Colombian Jewish pilot fluent in Dutch with even 10% chance of success, that would be very surprising, right? There might not be a vegan Colombian Jewish pilot fluent in Dutch anywhere in the world. If you were able to, based on the output of some mechanism, conclude that there was one of those in your small database of 300 people, it would be because of the output of the mechanism. So this baseline suggests that the baseline depends on how rare this predicate is in the population. Okay, so let's make it formal. We can define the weight of a predicate. The weight of a predicate is how common it is in the population. Okay, and then we can define a baseline, which is the best chance, the maximum over all trivial adversaries. So trivial adversary is one that doesn't look at the output of the mechanism. The best chance that the adversary succeeds in their game. And so what's the game? It's isolating one row in X, but also outputting a predicate that is at least as rare as W, right? So this baseline is a function of the parameter W. It actually looks like this. It's the blue line. So if your weight W is 1 over n, that was this born on February 2nd in a population of 365 people. So that's 1 over n. Then I'm going to use my mouse. Cool. So that's here. So the baseline is 37%. That's what we saw before. On the extreme other end of the spectrum, if your weight is really negligible, negligible for those who don't know is a technical term meaning negligible. It means extremely small, but essentially 0 for practical purposes. If your predicate is negligible weight, then the baseline is also negligible. Okay, oops. Danny just showed me my time. I'm behind. So any of these three yellow dots is an attack because you beat the baseline, right? And a better attack is to go higher. You're isolating more often, or to go to the left because you're using a more and more specific predicate. So the adversary's goal is to beat the baseline, and to do so, he outputs a low weight predicate that isolates a row with probability better than baseline. And the strongest type of attack is when the adversary is way down here, when there's a negligible baseline probability of success, but the adversary can output a very specific description of somebody and succeed with non-negligible probability. That's like this number 1. So that's the adversary's goal. So this is a security property, this orange line. A security property is, adversary can't do better than this orange line. There's a bounded increase over the baseline risk. So any of these 3 yellow dots would violate the security property. So here's another one. Some bounded increased risk up to some threshold weight, and then we don't care what happens. But since I'm low on time, I'm not going to read that definition. This is sort of the most general definition we consider. And the weakest definition we consider, which is to say the weakest security property, and again, we're focusing on necessity. So weak security property is going to give us strong negative results. the weakest definition that we consider is that you only have to rule out attacks like this attack, the vegan Colombian Jewish pilot. So we say that a mechanism M is PSO secure against predicate singling out attacks, if basically no adversary can succeed in outputting a negligible weight predicate and isolate with better than negligible probability. So that's our definition. That's what I'll refer to for the rest of the talk. We also consider a more general version. Cool. So I'm just going to show you some theorem statements in picture. Oh, wrong way. So one theorem is that predicate security, PSO security doesn't compose. So in pictures, it means that there are mechanisms where you can guarantee that that satisfy PSO security, that the best attacks are way down here. But if you use both the mechanisms together, then you can get attacks way up here. So PSO security doesn't compose twice. That's the theorem statement. You can also show that differential privacy implies PSO security. So DP gives you this purple line. It'll satisfy any one of our family of security definitions. But we don't have time for those. I want to tell you about k-anonymity, not because I particularly care about k-anonymity, but it's the best illustration of negative results and allowing us to prove state hybrid legal technical statements. Okay, so I'm going to move away from the math for a second. So this is a good time to tune in. So just as background, prevailing legal guidance from this regulatory agency or this advisory agency states that k-anonymity prevents GDPR singling out. This is a sort of a legal statement in a legal document. Okay, we're going to prove that k-anonymity doesn't prevent predicate singling out. In particular, there exist k-anonymous mechanisms that allow predicate singling out attacks with high probability. So here's the picture, right? We need to be below the orange dot. That's our definition, and there exists mechanisms that are way up here. Okay, so now for those who don't know what's k-anonymity, so here's an example. So this is the data set on the left. Every row is a random number from 1 in a large range, 1 to 2 to the n. And the k-anonymizer, here k is a number, it's equal to 3, outputs a database on the right where every row looks like 2 other rows. So there are groups of 3 rows are indistinguishable from each other. In this case, what the anonymizer is doing is outputting intervals. So it's saying these rows lie in the interval 1 to 27. These rows are in the range 343 to 729. So this is an example of a k-anonymous mechanism. And this allows predicate singling out attacks. So in particular, the mechanism reveals 2 rows for each one of these chunks. So for example, we know how the mechanism works in this case. And because we know how the mechanism works, we know that 343 was in the data set. So the adversary can look at the output and output the predicate that says, is X equal to 343? Okay, so what do we need for this attack to be an attack? It needs to match exactly 1 row, which it does with high probability, unless there's 2 rows with the same value on the left. And it needs to have negligible weight. It has to be one of these extremely specific predicates. But to get an extremely specific predicate, all I have to do is make the range of possible numbers on the left as big. So since I chose 2 to the n, the weight is indeed negligible. So that's an attack. It's a specific attack on a specific mechanism. But in fact, there's a general attack against general mechanisms. There's a generic attack against general mechanisms. I think in the interest of time, I'm not going to tell you details of the attack. Suffice it to say that it works on general k-anonymous mechanisms. And here's the picture that it outputs. So again, this is our baseline. The simple version of our definition requires you to be below the orange thing. And the attack actually says that you get a curve of possible attacks. For any weight, you get like a corresponding attack success. And the shape of this curve depends on the mechanism. So there's some parameter eta, which depends on a mechanism, which tells you how good this attack will be. And there's natural mechanisms for which eta is 1. So you get this attack that is just a straight line here at 37%, meeting the baseline, meeting the trivial baseline over here, but at all ranges of weights, so even for very specific predicates. So that was a little fast, but if you didn't understand it, it's fine. Okay, now really, if I lost you, come back. No more math, I promise. Great. So now I claim that we've proved a hybrid legal mathematical theorem. And I want to sort of review how we got there. So started with a legal postulate established by the law that general purpose GDPR anonymization requires preventing GDPR singling out. Right? This is a legal postulate. And then we developed a hybrid postulate by formalizing this notion PSO security and arguing based on our analysis, which is not here, but you can read about in our law review article that's forthcoming. We argued this hybrid thing that preventing GDPR singling out requires preventing predicate singling out attacks. It requires PSO security. Now we have a math theorem. Once we have a mathematical definition or hybrid definition that operates in the mathematical realm, we can prove theorems about it. So we prove that there are k-anonymous mechanisms that are not particular PSO secure, specific ones, and also that there are generic attacks that get you this sort of mechanism-specific parameter, success parameter. And so all of these things together imply a hybrid theorem, which is that there exists natural k-anonymous mechanisms that don't GDPR anonymize. In particular, any k-anonymous mechanism where this parameter is, at least a certain amount, doesn't GDPR anonymize. And this is a statement about, it's relating a mathematical property of like an algorithm and a distribution over data to a legal consequence, a legal standing of that algorithm under European law. So that's the type of thing that I mean a hybrid theorem. So maybe you disagree and you think we got it all wrong and this is we're full of it. The security notion is wrong. But in any case, this is like a type of argument that the type of argument that we're going for. But we still have to deal with the fact that we have this disagreement with the prevailing legal guidance. I said that the prevailing legal guidance says that k-anonymity prevents singling out. So what do we do about it, right? How do we square it? So option 1 is that the guidance presents a legal postulate and is correct by fiat, right? And then we'd have to change our definition. What we did doesn't make sense. So we think this is wrong. In particular, the working party is persuasive, but it's not binding guidance. And the document says so itself. It says the opinion reflects the views of the working party, which is advisory, but does not reflect the position of the European Commission. And also, while it's the most authoritative guidance that we have today, it's out of date. It was written for a predecessor of GDPR, not for GDPR itself. So option 2 is that the guidance, maybe we should just understand it as only applying in typical circumstances. As a cryptographer, I tend to think about worst case, but regulators aren't cryptographers. They don't have to think about the worst case. There's an exception to every rule. And the working party even recognizes that poorly used k-anonymity might allow singling out. If you, for example, they point out that if you omit some of the quasi-identifiers, which is something used in k-anonymity, if you omit some of the quasi-identifiers, then you're not going to prevent singling out. So it could be that the guidance is generally fine, despite some contrived counterexamples. So we argue that this is also wrong because the counterexamples are not so contrived especially the generic one, which applies to all mechanisms. And the failure or the attack doesn't arise from the sort of mistakes identified in guidance. It doesn't arise from, for those who know what this is, it applies just as well to L diversity. It applies just as well to T closeness and all of the other definitions. Has nothing to do with quasi-identifiers. Has nothing to do with homogeneity. All right. So it's a new type of attack. And so the third option is that the guidance is more like a conjecture. It was the best guess at the time. It could be wrong. We think this is the right choice, and the guidance sort of suggested itself. The technical understanding is evolving and may change. All right. So final point is that now it's sort of, now we want to throw it back to the policymakers. So it's time for policymaking to happen. In particular, each of these orange lines we can draw as a policy, and somebody has to choose the policy. You can tell us that, you know, our specific way of parameterizing it was wrong. I also think that it's the prevailing legal guidance is out of date. We think that it has some mistakes, so it's time to update the guidance, and in particular to take into account the ideas of the baseline and the weight, which were not have not been previously identified as important to this concept of singling out. We've included some model language in our upcoming law review article, and finally to recognize that composition won't happen by accident in GDPR anonymization. So I brushed over composition, but it's a very important thing for a workable privacy concept. And if it's going to compose, if GDPR anonymization is going to compose, it needs to be by design by policymakers. So finally, I'll just say that I won't say it. Cool. That's all I wanted to say. And I left, I think, some time for discussion. So I'll leave you with this picture and this slide.
I have one question that I'll start with, Aloni. I wonder whether, oh, we have a question. Does the person who posed it want to say it out loud, or you want me to read it? I'm not sure. I think in the interest of time, I will read it, but you're free.
Go ahead.
I'll go ahead and read it. This is a, okay, no mic. The question is as follows. It appears that the anonymizing black box breaks break provenance chain, resulting in invalidating machine learning explainability. More specifically, testing data authenticity and provenance pertaining to tort liability. If provenance chains are destroyed, what remedies should we expect to test authenticity?
Okay, so I think the question is about, you know, what if maybe anonymization might have a, oh, sorry. No, I got it. I can see it. You know, by anonymizing, we can make it harder to sort of trace where data is going and how it's being used, and maybe how it's being used for harm, for ill. And so I guess that's probably true. So just to be very, very clear, I don't think anonymization, sort of the dream of data anonymization is, you know, there was sort of the anonymization wars that Paul, who may or may not still be here, knows a lot about. And the position of maybe the computer science cryptography community was that anonymization, as it's commonly thought of, as it's being dreamt of, is not possible. So I'm not suggesting, I agree. I want to be very clear about that. I should have been more clear at the outset. So the dream of data anonymization is not possible. Nevertheless, the GDPR explicitly conceives of it, and other privacy laws also explicitly conceive of it. HIPAA I mentioned in the beginning, but essentially every privacy law is drafted in some way that explicitly or implicitly conceives of the possibility, at least, of legal data anonymization. And so the question remains whether or not specific computational techniques provide the legal guarantee. Whether or not we like anonymization, or whether or not we believe in the dream of dream of data anonymity.
And I would just say that I think that GDPR actually would consider the necessity of accountability to be a legitimate basis for processing. So I think the GDPR, the impulse of the GDPR is actually to want to retain accountability and authenticity. We have time for one final question, which I will ask if no one else does. So Aloni, I'm curious, you chose here a provision of the GDPR that is certainly important and does seem on its face susceptible to very direct support and validation or invalidation from a computer science perspective. That is, there's a mechanism that you can that I think you imagined and identified that sheds light on what singling out does and does not mean. I'm wondering whether, as a more general matter, you think there are classes of legal rules that are susceptible to this kind of approach and classes of legal rules that perhaps aren't susceptible to this kind of approach, and whether you have kind of a list in your head of what you can accomplish and what you can't, and what to do maybe with what can't be accomplished. But I'm interested in both sides.
Well, that's an extremely difficult question. I think all research is research, but like there is a sense in which, if we're just talking about sort of core computer science research, I could sort of see ahead for the next few years. I think in this sort of research, I know what the questions I'm asking are, but I don't know where they're going to take me. And part of that is that there aren't very many good examples of just, I think success story, I don't know if, whatever, I'll call it a success. Success stories are sort of still seem idiosyncratic. So I think that the places I'm thinking about are the places that I know about, which are sort of, so I come with the cryptography and privacy background from the computer science side. And by now I understand some of the law pretty well. Places to look for questions, I think places where there's, so we read a lot of legal guidance. So places where there's like well-established guidance, I think anywhere that you can find specific examples, concrete examples, instead of just English or legalese or abstract language. So this case was no good. This case is good. Here are some examples of singling out. So the guidance actually talks about some examples in like computer science studies of say, oh, look, you can single out a person with 5 location points. And you get clues about what they're talking about. So I guess that's I don't have a better answer. I think it's I know it when I see it after I've thought about it for a year.
No, I think that's a good answer when it appears that there's some pattern discernible behind the abstract rule. That may be a better.
And okay, I guess just if I can take 30 more seconds, I would say that places where we know that, like, we have computational techniques that are sort of substantively related to the legal question. So, for example, Sarah was talking about earlier this encryption question. So we have encryption, we really understand encryption, and then we have this compelled decryption business. So in this case, we have sort of differential privacy, we have anonymity, we have encryption. We have sort of a well-developed bag of concepts in computer science that we can sort of, we've developed some intuitions and we've developed some techniques that we can now think about very different questions than the ones we've thought about before. So I don't know, probably hard to do. I wouldn't know where to start if I wanted to think about similar questions for free speech, right? I don't know what speech is in computer science. I don't know where to root myself in computer science. if I want to understand, have sort of a computational formal theory of free speech.